Hi, this is Brett Sankis, the Right Brain Business Lawyer, and today we're talking about private placement memorandums, or PPMs, sometimes called confidential offering memorandums or confidential information memorandums, but PPM is the term you'll hear the most in the context of securities offerings. And so that's the context in which we're going to talk about them today. Sometimes you'll see them called confidential information memorandums when the whole business is being marketed through investment bankers or something. But this is about a PPM, what it is, what's in it, why you use it, all in the context of offering securities, stock or interest in an LLC to investors. So the first thing is, what is it? If you've seen one, it tends to be a fairly thick document, 50 pages, 70 pages, sometimes they come a little bit briefer, but it's this quasi-legal, quasi-business risk mitigation tool. It's this document that talks about what it is the business is going to do, what you're offering to investors, the risks involved. We'll get into a few more details about the sections, but fundamentally it's this document to lay out and show a court later on that here's what we told the investor. We gave them all the information that we could think of. We talked about the risks. We just laid out the deal on paper. So it tends to be pretty heavily lawyered. They take quite a bit of time to do them right. But that's what it is at a high level. It looks a little like a business plan, but it's a little less readable. It's a little bit more legalese, a little bit more about like the legal things and how things are going to work. That's what it is. When do you use them? So the first point is it's pretty rare when we're raising, number one, it's a private placement memorandum. So this is for when you offer private securities. Whenever you offer stock or other securities in the U.S. to investors, you need to either register those securities with the Securities and Exchange Commission and state security commissions, or you need to have exemptions from doing so. So when you're raising a couple $100,000, a couple $1 million, whatever it is, it just wouldn't make any sense to register the securities with the SEC. That's the idea. That's what going public basically is. It's a very involved, very expensive, time-consuming process. So when you issue securities in a private context, we look for exemptions. We look for an ability to do it without registering. And there's a lot of exemptions. They each have their own rules and nuances, but that's what we're doing. And so the PPM is for private placement, basically an offering of securities, private securities to investors. So that's the context. It is rare that you have to produce a PPM. It's definitely best practice in certain contexts, and it's definitely something you should do in certain contexts, but it's pretty rare you have to do it. So how do you know if you have to do it or not? So that depends on the amount of money you're raising and who you're raising it from and the exemptions that you're using. It would be, if you're raising $100,000 and you've got to spend $15,000 on an attorney like me to do it, which might make you fall out of your seat, but it's pretty inexpensive to do a lot of custom work on a PPM compared to the market. But that's, again, it's not cheap. So if you had to spend that kind of money to raise $100,000, it doesn't make a lot of sense. So you're going to, number one, if you're not raising a lot of money and you're raising it from people you know well, we're generally trying to figure out a way to not have to do one. I don't know how to give you better advice than that, but some of it is just depends on the risk profile of the deal. Now, if you're raising, someone came to me a couple weeks ago and said, do I have to do a PPM if I'm raising $100 million for this idea? You have to do a PPM. It's $100 million. Spending $20,000 on a lawyer's it sounds like a lot if you're raising 100. If you're raising $100 million, you're not willing to do that. I think you got to have your head examined. This is protecting you. So I'm trying to have a conversation with clients about what's good for them. You do it when you're raising a lot of money because it's a drop in the bucket to get the protection, the risk, to protect yourself a little bit, right? Then there's things like how many people you're raising money from. If you're raising money from a lot of people, the deal starts to look a lot less like a private offering. It doesn't look like an IPO, but at some point it doesn't look like what the SEC might call private offering. So you want to jump through certain hoops. And to jump through those hoops, sometimes you need to give the investors the kind of information that's in a PPM. So some of that's the number of investors. Some of it is is the industry you're in. So technology companies raising money from angel investors and venture capitalists. I was a venture capitalist during .com 1.0. I think out of 500 business plans I saw in the first year I was doing that, maybe I saw 2 PPMs. Like, that is not normal there. Venture capitalists aren't in the business of suing people. You got to really screw them over. They're in the business of taking risks. They are used to losses. It's okay. Now, the PPM helps avoid an argument that you said something or misled them, that there's a benefit of it, but it's just not normal in that world to use a PPM. In restaurant raises or real estate funds, hedge funds, stuff like that, definitely very, very common. They're kind of expected. You will often see films. I helped people raise money on a major motion picture a couple years ago. And yeah, we did a PPM because the investors are all asking about it. So you kind of raise red flags if you don't give it to them. So again, it's kind of a complicated question, but it's rare you have to do it. It's really a matter of having a good conversation, open conversation with someone like me about should I or shouldn't I? What goes in it? Let me give you a handful of categories of things. Number one is you will usually have a little bit of an opening summary about the opportunity. You will typically have a term sheet that lays out the key points of what you're offering, the deal. Is there a preferential return? How much does someone have to pay for a share of stock or a 1% interest in your LLC? That kind of thing. You will go into a section that's a deeper dive about the company, what it's going to do, the shape it's in right now, the milestones, like where it's at. The use of the proceeds, really important. How are you going to put that money to work? You typically will build in some flexibility there. This isn't set in stone. We need to be fluid as things develop, but you still want to give investors a good idea of where their money's going to go. Backgrounds of the management. What have they done? Not just whether they've done well, but if they have a huge failure, you want to disclose it. I know there's a lot of concern from clients sometimes, but this is about protecting your butt. They're thick documents that most investors don't read cover to cover and memorize. It's like you ought to. So I hope the investors read it, but the point is you don't have to be worried about disclosing some things. You shouldn't be afraid of that. Number one, it's the right thing to do, but number two, it's like you're disclosing everything, right? The good and the bad. So you shouldn't shy away from things like, if you lost some money, you had a failure. Maybe you don't put it on screaming headlines on page 1, but that's something you would cover. Again, this is a disclosure document. It should look good. It should present you and the team properly. It should fundamentally help you sell a deal. But the first and most important goal of it is it protects your butts. So disclose what you need to disclose. You're going to talk about the securities you're offering. What are the terms? We talked about some of that back in the basic term sheet, but how much do I pay? What do I get? What rights does that give me? Do I have some preferential treatment? What happens if you go out of business? Do I get paid back first? Stuff like that. You will give financial information about the business. Always, always, always. Even if you're not using a PPM, I tell my clients, definitely give a profit and loss statement if this business has been operational. Give a little balance sheet if there's nothing on it. You've got to have a record that you showed the investors what shape this business was in. That's really important. So in a PPM, you're always going to deliver some financials, historical and forecasts, and a balance sheet. You will also talk about how an investor subscribes. What do they need to do? What do they need to fill out? How does that go down? You'll have a whole big list of exhibits, which will be like the certificate of formation of the company, the bylaws or the operating agreement if it's an LLC. You may have some other, you might have collateral about the business. You might have milestones, goals. You may have press releases. You may have other sort of sales kind of documents as exhibits. And I skipped over because I want to come back and do a very deep dive on the most important section of the private placement memorandum, and that's the risk factors. So you can go online, you could buy a PPM for a couple $1,000. I probably don't need to tell you, you're not going to get a lot of custom work on that document, right? Lawyers, they charge different amounts, but there's very few charge $20 an hour. It just isn't where the market's at. So when you buy a PPM for a couple $1,000 versus, for me to do one might be 15 or 20 to really do it right, depending on the business, sometimes less. But And that's low. I mean, really, for the market. When I was in big law, we would charge $50,000, $60,000 for it. It sounds crazy, but it's a lot of work to do it right. And when you buy something off the shelf, what you get are these canned risk factors. Oh, the business won't do well if we don't have good people, and if the economy turns down, we'll get hit. And look, that maybe it's better than nothing. I could argue it differently. Courts definitely have made it clear over the years that the obligation on you is to disclose the real risk factors, the reason this business will fail if it fails. And you need to spend some time on that. You can go to sec.gov, their website. You can find risk factors for similar businesses. Those are publicly filed documents. They're usually very well lawyered. So you can start to do some of this and pull these things together, but you really have to be intentional and clear and draft those properly. They should be in order from greatest risk to kind of descending order from the most significant risk. Typically they'll be categorized, like risks about this industry, risks about this particular company, risks maybe about this offering, what you're buying. But the risk factors are critical. It's really important that they be clear and thorough, and they be the right risks. And it's not to say something won't come up that you never thought about or never saw, but the point being, if the business goes down for something that should have been obvious up front and you didn't talk about it because you just have some canned risk factors that said, well, if we fail, it's because the market was bad and our people, we got the wrong people, you're going to be in some trouble. I mean, I wouldn't want to be defending that case. So risk factors are really, really, really critical. The SEC at sec.gov, and I forget the exact URL, but it's like something industry guides, has these certain types of industry guides for certain types of businesses. And they're really good go-by for the kind of things you should have in your PPM, in some cases need to have in your PPM for certain types of businesses, including oil and gas and bank holding companies, insurance companies, I think, mining companies, kind of a random mix of things, but it's really good, these industry guides, for things that you would want to think about putting into your PPM. So just to wrap up, again, it's kind of a PPM 101. It's rare you have to do this, okay? And they come in very different flavors in terms of size and what you say and what you disclose. But for certain types of offerings, securities offerings, you should do a PPM. For others, you probably want to do a PPM. It's an important question to talk to your securities attorney about. Does this make sense? Do I need this? Is it worth it in the grand scheme of what we're doing here? So if you have questions about this, visit businessattorneyinaustin.com. There's a lot of articles about PPMs, or reach out to me. Happy to have a conversation with you.